स्टार्ट करिए।
Thank you. Hearty good evening to all. Welcome Sumit sir, Mamta ma'am,
Thank you.
welcome.
Thank you. Thank you.
Suvinder sir, I can see Suvinder Singh Tik sir, our associate, and IInd sir, Asit ji, Prasad ji. Welcome to all of you. And the way we are, Mamta ji, I think got disconnected. Namaskar, Prasad sir. So, sir, can we stop the background music?
Yeah, I've stopped it.
Hey.
Thank you. Namaskar, ma'am.
Namaste, namaste.
Good to see you, ma'am.
Good to see you all.
Yeah. So, as all are aware that as IIPA, we are conducting a series of webinars. So you can say keep the members abreast of recent developments and about what is going on in the insolvency field. So continuing with that, we have come up with this topic, liquidation aspects as a going concern. Practically, this is a very relevant topic in today's scenario because right now, if we can see, when you can say insolvency CIP processes started earlier, now you can say most of the organizations are going into liquidation, maybe as a going concern or segregatedly. But Sumit ji will be, you can say, taking up this session. We will be looking forward to Sumit sir for this session, and we have with us Rajiv Khurana ji. I think sir has joined or not. Khurana sir. I think Khurana sir has not joined yet. So he has worked with Khurana sir has worked with Central Bank and State Bank of India. He's having 39 years of experience. Having you can say worked in various different type of domains, banking sector, and he'll be here with us. He was here with us in the last session also, and we learned a lot from him. A little bit about Sumit sir, I would like to share with you. Sumit sir, while going through your profile,
yes,
I was that you are the first person to qualify this examination. Congratulations for that. But
thank you.
I would like to share that I'm the first CMA to qualify this examination.
Oh, great.
First CMA is, you can say, welcoming the first qualified IP over here. So, welcome, sir. Sir, I have heard a lot about you. Let me tell you frankly, because luckily, one of the organizations where you were appointed as IRP earlier, that won 12 cases. So I had worked as cost auditor with one of the companies. So I know you. So, sir, a bit about Sumit sir. He has all the 3 degrees practically, CMA, CA, CS, and specifically he got the rank in CA Institute, and he has done a lot of work in the insolvency field and practically set the different type of benchmarks in the insolvency regime. If you go through, I have a very, very big profile of his, but I'm just going to touch upon the little bit specific things which I have come across. One, sir has mentioned specifically that his favorite school song titled Courage is Destiny. Practically, it has been mentioned. Definitely, this is a very good thing. And if you have the courage, you can achieve whatever you want. Practically, that is the same motto we are following. And as an IP, we must have the courage to take the decisions where the law is not clear. Only then we can perform our task. Otherwise, it is really very difficult to perform because everything is not written in the law. We all of us are very much aware of that. And when nothing is written in the law, how we are going to practice that law, that is of very much relevant thing. And I think Mamta ma'am, Sumit sir have set the benchmarks in many, many areas. So looking forward to you.
तो join नहीं करा आपने?
Manoj ji, you are, please mute. So we will just try to learn a lot from you during this session. And I can tell one thing that this session is definitely going to benefit all of us who are carrying on certain processes and maybe moving forward for having a few processes which will be, you can say, turning into liquidation at a later stages. This session will definitely help us a lot. Manoj ji, over to you. I have briefed about Sumit sir and Verma sir. Over to you, Purana sir.
Thank you very much. Thank you, Navneet ji. Thank you very much. हाँ जी, ममता जी नमस्कार, सुमित जी नमस्कार।
नमस्ते नमस्ते नमस्ते
नमस्ते। मैं एक्चुअली वो अपने चीफ गेस्ट सर राजीव खुराना जी को फोन मिला रहा था, तो शायद कनेक्टिविटी क्योंकि प्रॉब्लम है वो मिल नहीं पाए। एक बड़ी अच्छी खबर है उनके लिए आज। उन्होंने कल ही हमारे साथ इंस्टॉल, अभी एक मिनट,
राजीव खुराना जी आ गए सर।
हाँ एक मिनट, मैं करवा रहा हूँ। हाँ जी राजीव खुराना जी, आप लेजिबल हो? आवाज आ रही है आपको?
Audio is getting connected.
Yeah, audio is getting connected. Yes, yes. Hello.
Hello. Welcome Khurana sir.
हाँ जी।
नमस्कार नमस्कार। मुझे ध्यान में था कि 3:30 बजे का है।
नमस्ते राजीव, वेलकम।
ये हम जितने भी आईपा की हमारी फैमिली है और हमारी स्पेशली मैनेजिंग कमेटी है और जो लोग हम लोग यहाँ पे प्रेजेंट हैं, मिस्टर नवनीत जी, मिस्टर ममता जी एंड ऑल अदर आल्सो, मैं सबकी तरफ से आपको बहुत बहुत मुबारकबाद दे रहा हूँ जी। कल इन्होंने 70.5% मार्क्स लेकर इंसॉल्वेंसी का एग्जाम क्लियर करा है और नाउ ही हैज आल्सो बिकम पार्ट ऑफ आवर फैमिली।
कांग्रेचुलेशन सर, कांग्रेचुलेशन।
थैंक यू सर, थैंक यू
सर। ये सेलिब्रेशन का कॉज है, जब भी आप नेक्स्ट टाइम हमारे को मिलेंगे आप तो मिठाई आपको जरूर खिलाएंगे।
ट्यूसडे को मिठाई खिलाएंगे सर आपको।
तो आईपा की तरफ से हम आपको मिठाई जरूर खिलाएंगे। इट्स अ वेरी टफ एग्जाम नाउअडेज। जब हम लोगों ने पास करा था उस समय इतना ज्यादा टफ नहीं होता था, थिंग्स वर नॉट सो, बट नाउअडेज। और उसके बाद फिर सर ने गेटिंग 70.5% मार्क्स, इट्स रियली अ वेरी वेरी बिग अचीवमेंट। और 70.5% मार्क्स लेना, इट्स समथिंग वेरी।
थैंक यू सर, थैंक यू।
तो हमारी तरफ से आप सबको बहुत बहुत मुबारक।
थैंक यू सर, थैंक यू।
ये कुछ डिस्टर्बेंस आ रही थी तो मैंने सबको म्यूट कर दिया है। तो जैसे ही प्रेजेंटेशन शुरू होगी तो वी शुड स्टार्ट विद इट। ओके, जैसा कि हमारा सिस्टम यहाँ पे है, यानी कि वी हैव इट। सर आपकी नवनीत जी, आप चाहो तो थोड़ी सी इंट्रोडक्शन सर की राजीव जी की दे दो। वैसे आपने दे दी थी पहले, अनम्यूट कर लो अपने आप को।
I'm just telling again about Khurana sir. Khurana sir, formally we are welcoming you, and sir was kind enough to, you can say, spare his time earlier also, and today also he has come over here. Last time when he came over here, he was not an IP. Now he is a qualified IP also. So welcome, sir. So sir has worked with the SBI and Central Bank, having 39 years of experience in different domains of banking, practically in forensic audit and resolution of stressed assets specifically. Sir, this area is specifically for you. Now you have become an IP, and definitely we will seek your guidance further also in this area. You are a qualified IP having so much of experience in handling stress assets. Apart from that, you have handled forensic audits also. So you are a perfect case for handling different type of CIRP processes. I must say that. Welcome, sir. Welcome. Over to you, Manoj ji.
Yeah. Thank you. Thank you, Navneet ji. Thank you very much. As usual, जैसा हमारे यहाँ पे सिस्टम है, I would like to start with my presentation. But I'm really happy. After my this presentation, I am receiving many attacks, many phone from many people who are just asking me, for the cases which I have generally discussed in my presentation, just to go a little bit deep into it or just to discuss with it. It shows that people are liking it, and I'm really thankful for that. I'm just starting my presentation, please. Hopefully, my screen is absolutely visible the way I want.
Visible, sir.
Okay. This is my small introduction. This is introduction of IIPA, which traditionally we give every time. Our program will be divided in three parts. I'll be taking 15 minutes for latest developments and issues of IP, and 1 hour by our respected Mr. Sumit Benani. And later on in the 15 minutes, we shall have a panel discussion, whereas me, Mamtaji, Nileshi, and will be joining us. Definitely along the speaker also. And in fact, आगे से मैं खुराना साहब को नाम भी लिख दिया करूंगा, because he is also very good in answering many questions. Okay, today I am divided my development and issues with IPs in three parts. One is we were having a meeting with the very senior officers of the persons who are controlling IBC. And it was a very fruitful meeting. I just give you the background of the meeting. Actually, what happened recently, in fact, right now also, a lot of cases are coming against disciplinary proceedings are being done against IPs. As a result of which, they were a very, very much worried lot. And many of the IPS who get affected with DC notices, they always approach us and say, कि IIPA as an association क्या काम कर रही है? So, the keeping that thing in mind, we hold it some internal meetings, and when we hold it all those internal meetings, and then that particular those meetings, we things came out to us that we should have a dialogue with the senior officers who are responsible for issuing all these notices, or who are doing this thing. So that was the purpose. We thought of having a meeting with them, but initially we thought of discussing with them disciplinary cases only and effect of that. But later on, in fact, initiative was taken by me mainly. Then I said that let's start a dialogue with them, and later on when we have a common way of that, because what happened is that initially when you meet anybody first time, everybody has apprehensions against you, and let's have a meeting with them and discuss with them some general issues, and later on we shall go for the issues which are which are worrying to our IP community. In that context, we are having a very, very good meeting. So we most of the IPA the persons are there. Me was there, Amneet ji was there, and Nilesh Sharma ji was there, along with Mr. Madan, as a very senior director was there. Mr. Anil Jain was there, and two associations also joined us. Association of Professionals and DIPA Association also. Their representatives are also there. We were having a wonderful interaction with them. We thought of sharing that interaction on WhatsApp group, but then we thought that if we start sharing like this, then it will may have some ill effect otherwise also, because people may say that IPA is going for all this thing, popularity on all things. That is why we avoided all things. But what talk we have? I mean, it's a very, very important talk. It will clear a lot of doubts of we practicing IPS. I'm sharing with you in brief what we ask them and what they reply to us in brief. Since everybody is worried, every practicing insolvency professional is worried a lot that he has to fill one information at 3-4 places. We raised a concern with them that this multiplicity of filling of information should be either avoided or should not be there. They responded very well. They said, how we can do it. They were so cooperative. They said, how we can do it. You give us a proposal, then we gave them a proposal that you can develop a software whereby once any particular information is filled there, that can be auto-populated to all the sites wherever it is on. It is required, like IBBI or NCLT or IIPA agency or any relevant agency. They were so happy. When we said them this thing, they said, okay, now how we are in the process of developing that software. If you want, we should do it more expediently. If you have anybody who has a good knowledge for that, give us 5-6 persons who understands IBC also and information technology also. We should do it in a more speedy manner. For that, we all the persons who were sitting there, we asked them, ki, let's go for it and create a group which can help them. So we are on the verge of, zeroing some person. In fact, if any among audience, if they also can help us or the government officers in speeding up this particular job, they can also refer some persons to our office. We can also, take their services. So at the end of the day, they also understood our problem and they said that we shall be multiplicity of forms of filing is there that we shall reduce as much possible as we can do. Okay. CPR is a big problem, and this problem will, go on increasing day by day. We told them that at present CPR is being granted by either agencies or by the seminars held by the IBA only. On the other hand, if we see our parallel institutes like CA, CS, CM Institute, they authorizes yeah, associations, chambers, non-profit organization, and all these people to, have meetings and do the CPR for which in fact they heard this suggestion from our side first time, but they were very receptive. They said, okay, yeah, give us a proposal and how we can do it. We shall go for it and we shall allow जैसे आज हमारी मीटिंग हो रही है, अब इसके अंदर हमारे को सीपी आवर्स नहीं मिल रहे, तो उन्होंने कहा जी आप हमारे को बताइए कैसे इन चीजों को फॉर्मुलेट किया जा सकता है. We shall willingly come with you and allow associations and chambers to grant CPRs to the members. Third thing we asked them was that from our experience working in professional capacity, we asked them that many a times अगर IRP या RP चेंज होता है या IRP की जगह पे RP नया आता है, तो जो आउटगोइंग RP या IRP है उसको फीस मिलने में बड़ी दिक्कत होती है या उसकी रिकवरी के अंदर बहुत टाइम लगता है. तो ये हमारे प्रोफेशन के अंदर ये सिस्टम होता है कि जब भी कोई इनकमिंग ऑडिटर या प्रोफेशनल आता है तो वो उससे एनओसी लेता है. तो why not to start that system in IBBI also? Because what happen is that we have seen practically कि जब भी हम एनओसी के लिए कहते हैं तो जो भी नया बंदा आता है वो कहता है कि पुराने वाला बंदा मेरे को एनओसी तब तक नहीं देगा जब तक आप उसकी फीस नहीं दोगे. So, it can act as a motivating factor for the incoming person also, and ये जो COC कह लो या जो भी स्टेक होल्डर्स हैं उनको भी एक रिस्पॉन्सिबिलिटी रियलाइज होती है. तो यानी कि दे कैन आल्सो डू इट एंड दे कैन आल्सो डू इट. तो इस चीज को मद्देनजर रखते हुए दे वर वेरी पॉजिटिव. दे सेड कि हम इसके लिए कुछ ना कुछ करेंगे. वी हैव गॉट नोटेड देम दिस थिंग. So maybe in the coming days, this sort of system may get started for our IRP, RP assignments also. तीसरा हमने चौथा इशू हमने उनसे ये लिया कि जनरली कोर्स जो होती हैं जब भी कोई IRP अपॉइंट होता है तो उसको 2 लाख रुपए, 1 लाख रुपया या 50,000 रुपया या मे बी लाइक दैट करके एडिशनल पेमेंट्स के लिए एप्लीकेंट को कह देती है. बट इट हैज नो बैकिंग ऑफ लॉ. It is a practice, but it has no backing of law. We requested them कि let this particular person have the backing of law. They they agreed with this and their response was very good. They said कि आपकी suggestion तो बिल्कुल ठीक है जी. So let's see how we can put it in writing there. So that suggestion has also given to them from our association IIPA. Now our fifth point was that we said that when we appointed as an IRP RP, तो हमारे को जैसे हमारी इंस्टीट्यूट हमारे को कार्ड इशू करती है, आइडेंटिटी कार्ड इशू करती है, ऐसे आप आईपीस को भी आइडेंटिटी कार्ड इशू करो, वेयर बाय यू हैव सीनियर गवर्नमेंट ऑफिसर्स लोगो आल्सो फॉर ऑल आईपीस. तो इसके बारे में दे सेड कि वी हैव टेकन दिस मैटर अर्लियर विद द मिनिस्ट्री ऑफ कॉर्पोरेट अफेयर्स आल्सो. तो उन्होंने हमारे को मना कर दिया था कि आप आईपीएस को ऐसे कार्ड इशू नहीं कर सकते. तो मैंने कहा कि फिर अगर आप परमिट करो तो हम सेक्रेटरी एमसीए से जाके बात कर लेते हैं कि व्हाई दिस कांट बी इशूड व्हेन अदर प्रोफेशनल बॉडीज आर इशूइंग अस. तो कह रहे जी इट्स योर प्रोरोगेटिव बट दे दे वर वेरी 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 नीट एंड क्लीन इन देयर सेइंग दैट कि अगर हम कुछ नहीं कर सकते तो नहीं कर सकते, तो हम इसके लिए आपको जहां पे क्लोज करना पड़ेगा वहां पे आप करिए. Okay. Another issue is that the uniform expiry dates for the all AFL. In case of DFL, basically I'm telling you कि what happens is that कि हम लोग जब भी पैनलमेंट करते हैं क्या नाम इसका ये IBBI के अंदर जो कि इनका 6 मंथ का टेनर होता है, तो उसमें 50% लोग पैनल कर पाते हैं, 50% लोग पैनल नहीं कर पाते. जो लोग पैनल नहीं कर पाते उसका मेन रीजन यही होता है कि उनका AFA जो है वो उस पर्टिकुलर पूरे 6 महीने के अंदर में किसी भी डेट के अंदर इन बिटवीन एक्सपायर हो रहा होता है. तो हमने उनको बोला कि इसमें हमारा क्या फॉल्ट है, तो ये तो आप अपना कुछ प्रोग्राम चेंज करो, EFA की ज्यादा टेन्योर को बढ़ाओ, यानी कि इंस्टेड ऑफ इशूइंग इट फ्रॉम year to year basis, you issue it either on a calendar basis or you issue it in maybe up to if not on calendar basis up to the next 30th June or 31st December, or so that everybody is eligible to be get panel there. देखिए पैनलमेंट करके काम मिले या ना मिले, लेकिन हमारा राइट है हम अपने प्रोफेशनल बर्गर्स के लिए जितने पैनल की अपॉर्चुनिटीज क्रिएट कर सके उनके लिए करें. तो फॉर दैट रिस्पॉन्स फ्रॉम द वाज वेरी पॉजिटिव. दे सेड कि इस तरह की कंप्लेंट हमारे को ऑलरेडी पहले भी आई हैं, तो वी शुड ट्राई टू इम्प्लीमेंट इट. और प्रैक्टिकली मर्ज करके कंसेंसस यही मर्ज हुआ कि जो पहला वो क्या कहते हैं एएफए इशू होगा वो सपोज कर लो अगर किसी का जैसे इस समय अगस्त चल रहा है, तो अगस्त से अगस्त का नहीं होगा, वो अगस्त से लेके दिसंबर 2023 तक का इशू होगा. फिर उसके बाद सब्सिक्वेंटली वो कैलेंडर वाइज इशू करते रहेंगे, देन देयर विल बी नो प्रॉब्लम. फॉर दैट दे सेड कि आईपीए वाले कहते हैं कि फिर एक ही बार हमारे को बहुत सारे इश्यूज करने पड़ेंगे. तो फॉर दैट मदान सर रिप्लाइड वेरी क्विकली. ही सेड कि सीए के अंदर 2.5 लाख मेंबर है, वो भी तो इशू करते हैं आजकल. एवरीथिंग इज ऑटोमेटिक एंड दीज आर टेन रीजन नॉट टू बी लिसन्ड. तो दे दे एग्रीड फॉर दैट कि वी शुड डू समथिंग पॉजिटिव फॉर दैट. Okay. We practicing chartered accountant know, especially tax practitioners knows that we have a system of advanced ruling. Advanced ruling system is like that. Wherever you have any doubt in interpretation of anything, in fact, हमारे यहाँ IBC के अंदर तो अभी मैं आपसे डिस्कस करूंगा कि एक पर्टिकुलर प्रिजन की जुडिशियल अथॉरिटी इंटरप्रिटेशन एक्ट देती है, और उसके बाद जो एपीलेट अथॉरिटी है एनसीएलटी है वो एक्स को वाई में कन्वर्ट कर देती है, और अल्टीमेटली सुप्रीम कोर्ट जो है वो वाई को जेड में कन्वर्ट कर देता है. व्हाट आई मीन टू से इज दैट कि इश्यूज आर सो टिकिश, इश्यूज आर सो इंटरप्रिटेशनल कि वी रिक्वेस्टेड देम कि लेट्स हैव सॉर्ट ऑफ एडवांस रूलिंग फ्रॉम देम. तो जैसे एडवांस रूलिंग का मैकेनिज्म होता है वेयर बाय इफ वी हैव एनी डाउट, तो एनआरआईज के लिए जनरली ये एप्लीकेबल होता है कि दे कैन गो एंड आस्क देम कि इस इशू के ऊपर आपका क्या ओपिनियन है, एंड देन अकॉर्डिंगली वी एक्ट टू इट. And they were happy to listen from us कि चलिए they were not much aware of कि this sort of system is there. When we told them, they were happy to it. In fact हमारी मीटिंग 16 तारीख की हुई थी, तो वो कह रहे थे कि हमारी 17 को उनकी बोर्ड मीटिंग है, we should take care this is the board meeting also and put this agenda in the board meeting also कि this demand has come from your side. Okay. सेक्शन 27 है. सेक्शन 27 सीओसी को पावर देता है टू रिप्लेस IRP-RP with 2/3 of their majority. Practically, we have seen it that this particular, because of this particular power, and let me talk very frankly. IRP-RP का liquidator जो हम लोग काम करते हैं, we loses our independence. Because we always know कि हमारे big boss ये हैं. We need to satisfy to them, and और स्विस लेवन का केस में सुप्रीम कोर्ट ने जब उसके बाद जितनी भी सब्सिक्वेंट जजमेंट्स आई हैं उन सब जजमेंट्स के अंदर ये इंटरप्रेट करा है ऑनरेबल सुप्रीम कोर्ट ने कि दिस इज दिस इज अ कमर्शियल डिसीजन एंड नो कोर्ट कैन इंटरफेयर इन द कमर्शियल डिसीजन ऑफ COC, मीनिंग देयर बाय दैट दे हैव अ पावर where they can replace IRP-RP with 2/3 majority, and this power is maybe I wouldn't say it abused also, but it has some limitation. So we told them कि let's have a you please we demand that this power of COC should be diluted. तो उसके जवाब में उन्होंने ये कहा जी ये कहते जी ये this is not in our power. If you want to amend this dilute this power or amend this thing therein, you have to approach to our higher authorities. So what I mean to say is that it was a negative reply from their side. मेन इश्यू जो था क्या नाम इसका बहुत सारे आईपीज के अगेंस्ट स्टेक होल्डर्स कह लो या अदर देन स्टेक होल्डर्स कह लो, वो कंप्लेन्स बड़ी फाइल कर रहे हैं। जब वो कंप्लेन फाइल कर लेते हैं तो इमीडिएटली कंसर्न आईपी को शो कॉज नोटिस इशू हो जाता है एंड इट हैज ऑल इन इफेक्ट। तो वी डिस्कस दिस मैटर इन डिटेल विद देम। We said that this is becoming a very frivolous complaints are coming from a lot of quarters, but it is hampering the work of the IP. And many a times, as I noted on, complaints are frivolous, and complain कोई बाहर वाला करता है और डिटेल्स आप आईपी से मांगनी शुरू कर देती है, और दैट टू विद इन ए वेरी लिमिटेड टाइम। तो इसके बारे में we need to do, we request IBBI to act as a big brother and need to do something good for us. तो उसके बारे में वी हैव अ लॉट ऑफ डिस्कशन। मैं इसके अभी बीच में जाना नहीं चाहता, बट यू कैन जस्ट गो थ्रू इट। तो वी हैव, बट इस चीज को थोड़ा सा ठीक करने के लिए वी एज एन एसोसिएशन ऑफ आईपी हैज टू डू मोस्ट प्रॉब्ली मोर हार्ड वर्क। तो अभी शुरुआत है, लेट्स सी टू इट। ओके, अनदर वी प्रपोजल वी गेव टू देम इज दैट कि जैसे एम्पैनलमेंट के लिए बैंक्स वगैरह कॉल करते हैं, तो इनकी अपनी साइट्स होती है, वहां पे कर देते हैं। एज अ रिजल्ट ऑफ व्हिच इट डजंट रीच टू मेनी एडवांस माइनी आईपीज आल्सो, और डेट वगैरह निकल जाती है तो उसमें दिक्कत होती है। ऑन दी अदर हैंड आईबीबीआई की आप देखें तो उनकी डेली बेसिस पे मेल आती है। तो हमने कहा जी आपकी डेली बेसिस पे मेल आती है, आपकी साइट के ऊपर सारी डिटेल्स होती है। तो इस तरह की एम्पैनलमेंट की अपॉर्चुनिटीज जो भी हम लोगों के लिए आती हैं, तो यू पुट इट इन योर website, and whenever it comes out to be there, so you place it in your daily mail also, for which they were very happy to listen from us. They said this is a very good ये क्या कहते हैं suggestion from your side। तो हम आईबीए से लिंकिंग करके और बाकी जगह पे जहाँ पे आपकी एनरोलमेंट वगैरह होती है, हम उनको बोलेंगे कि ये जो आपकी जब भी आपकी कोई रिक्वायरमेंट आती है, इसको ब्रीफली आप हमारे यहाँ पे पोर्टल पे पुट अप करें। Police authorities should be directed not to register any FIR against IP or any action decision taken by him during period for liquidation without permission of the NCLT। हमने उनके पास एक डिमांड करी कि भैया ये बड़ी भी एक दिक्कत वाली बात है कि जो भी उठता उठा के हमारे केस पुलिस में कंप्लेन कर देता है ना, वी फील वेरी बैड। इसके बारे में उन्होंने कहा जी आप पब्लिक सर्वेंट बन जाओ। तो पब्लिक फ्रंट के लिए उन्होंने कहा कि थिंग्स आर गोइंग इन हाई कोर्ट आल्सो, वेयर बाय समबडी हैज रिटन टू अस कि आप हमारे को बताइए इफ यू वांट टू बिकम ए पब्लिक फ्रंट डू लेटर बट आरएनडी, इसके प्रॉस कॉन्स क्या है। हम दिल्ली हाई कोर्ट को कहते थे कि वी डोंट हैव एनी ऑब्जेक्शन, एंड दैट केस यू विल बी सेव्ड ऑफ दिस सॉर्ट ऑफ हैरेसमेंट इन द हेड्स ऑफ पुलिस। तो वो हमारी एसोसिएशन जब उनसे बात हुई, तो हमारे प्रणव भी थोड़ा सा इसके ऊपर काम कर रहे हैं, बाकी एडवोकेट्स भी इसके ऊपर थोड़ा सा काम कर रहे हैं। वी आर टेकिंग लिटिल बिट ऑफ टाइम टू अंडरस्टैंड कि इससे कौन क्या है। प्रॉस तो हम सब लोगों को पता ही है। Once we are able to analyze what cons are there, then we may have a submission with them, with authorities, and see to it keep how we how we are able to how government is allow IPs to be a public servant. But in fact, the supported our view. In fact, suggestion has come from their side also to become to make IPs public servant. Many a time it is seen that IP is not able to attend workshops, especially of IBBI, which is generally free of cost because of having the attending of 100 there, or some sort of restriction is there that you should have earlier attended basic workshop, something like that. You said this is not required. I told them that I qualified 5 years ago, approximately 5 years ago. Why should I attend them some basic workshop? Initially, there was no basic workshop, and after that, when I handle the assignment, I don't require those basic workshops. They said that this sort of restriction we shall remove, in the days to come. These are the all I thought of sharing with my colleagues. And if anyone among the audience have any suggestion, he can share it either in the chat box or can mail to me later on also. That is there. Now I move to the second aspect, which is more important. I always discuss my latest judgment. The first judgment which I will be discussing today is this is very recent judgment. Sundaresh Bhatt versus Central Board of Indirect Taxes, and this judgment has come yesterday only. In this case, the court held that IRP liquidator has a right to take control of the assets belonging to the corporate debtor in terms of code after moratorium under section 14 subsection 33 subsection 5. बेसिकली व्हाट हैपन कि इस इसकी जो क्रक्स है जजमेंट की वो मैं आपको बता देता हूँ. सम गुड्स वर बीइंग इंपोर्टेड और उसके अगेंस्ट कुछ कस्टम ड्यूटी वगैरह पे करनी थी, वो पे नहीं हुई. जब पे नहीं हुई तो ये कस्टम अथॉरिटी ने उन गुड्स को अपने यहाँ पे इम्पाउंड कर लिया. और जो आरपी था उसने कहा कि ये गुड्स जो है ये मेरी से बिलोंग करते हैं, और अगर आपने इसको इम्पाउंड करा तो जो आपकी ड्यूटी बनती है उसका मेरे पास क्लेम फाइल कर दो, बिकॉज मोरेटोरियम वाज गोइंग ऑन अंडर सेक्शन 14 और अंडर इन दिस कंपनी लिक्विडेशन वाज आल्सो under the section 33 subsection 5. Matter traveled up to the Supreme Court. Supreme Court agreed with the contention of the RP, and they said that as per law, IBC will prevail over custom duty. This is the first law against indirect taxes. एंड अगर कस्टम अथॉरिटीज को डायरेक्शन दी गई कि आपकी जो ड्यूटी बनती है उसका आप उसी का क्लेम फाइल कर दीजिए, और जो गुड्स हैं इट विल बिलोंग टू द सीडीओ. ये एक बड़ी लैंडमार्क जजमेंट थी व्हिच आई थॉट ऑफ शेयरिंग विद यू. दूसरी मेरी जजमेंट है दिस इज अगेन सफायर टेक्नोलॉजी प्राइवेट लिमिटेड वर्सेस डिजिटल प्रोविडेंट फंड कमीशन एंड अदर्स. इस केस के अंदर सिर्फ मैं ये जजमेंट मैंने इसलिए ढूंढी है बिकॉज इस केस के अंदर ऑनरेबल सुप्रीम कोर्ट ने कहा है कि जो हमारी अपील फाइल करने का टाइम 61 डेज का है विद इन 30 डेज, तो इट हैज टू बी स्ट्रिक्टली कंसिडर्ड. You have to file appeal against adjudicating authority order within the 30 days, otherwise your appeal will become null and void. But I'm really surprised if I see my tax practice. So tax practice I have seen it. Courts, even IIT कह लो, the high courts कह लो, honorable supreme courts कह लो, 600-700 दिन का वो delay को condone कर देते हैं only on the context justice should prevail. Justice should be provided to everybody, and for technical faults it should not be applied. But in this case, honorable Supreme Court has said this thing, so we need to obey their say. So meaning thereby कि जब भी हमारी कोई अगर हमारे को जुडिशल अथॉरिटी ने एनसीआर के अंदर अपील फाइल करनी है, तो वी नीड टू फाइल इट विद इन 30 डेज. या दिस इज नॉट द जजमेंट जो हमारी पिछली एक महीना पहले मीटिंग हुई थी उसके और आपके बीच में. somehow this I thought it as a very important judgment. हम लोगों ने पता नहीं इसको पहली प्रेजेंटेशन में मिस कैसे कर दिया, तो इसको मैंने इस बार ही लिया है. दिस इज द नोएडा वर्सेस Anand Sonbhadra. I explained you the facts of this case to understand that this thing. What happened in this case? Noida Authority provided the land to the on lease to the city. जब नेचुरली लीज एंड पे नहीं हुआ, जब लीज एंड पे नहीं हुआ तो नोडल अथॉरिटी की कंटेंशन ये थी कि इफ वी इंटरप्रेट सेक्शन 5 सबसेक्शन 8 व्हिच डील्स विद द फाइनेंशियल डेट, उसके बाद उसकी एक सब क्लॉज है, तो जो उसकी सब क्लॉज है, सब क्लॉज डी है, 5 सबसेक्शन 8 सबसेक्शन सब क्लॉज डी. तो उसके अकॉर्डिंग उन्होंने कहा कि हम फाइनेंशियल क्रेडिटर हैं बिकॉज इट इज रिटन इन दिस पर्टिकुलर सेक्शन दैट एनी अमाउंट ड्यू अगेंस्ट एनी लीज एंड लाइक दैट करके है. और साथ में नोडा अथॉरिटी ने ये कहा कि उन्होंने एक इंटरप्रिटेशन ली सेक्शन 3 सबसेक्शन 33 की, जिसके अंदर उन्होंने सेक्शन 3 सबसेक्शन 33 डिफाइन करता है ट्रांसैक्शन का. तो ट्रांसैक्शन के अंदर वो ये कहता है कि any transaction which is not only related to money but in kind also shall be treated as a transaction, a valid transaction therein. तो उन्होंने ये कहा कि हमने जब इनको लीज पे लैंड दी सीडी को, इन्होंने मान को लीज लैंड पे नहीं करा, तो इफ वी हार्मोनियसली हम इन दोनों को इंटरप्रेट करते हैं, वी आर द फाइनेंशियल क्रेडिटर. सुप्रीम कोर्ट बट ऑन द अदर हैंड सीडी वाज सेइंग कि दे आर नॉट द फाइनेंशियल क्रेडिटर and they are the operational creditors only. Honorable Supreme Court, took cognizance of both the section 5 subsection 18, section 3 subsection 33. तो और उसके अंदर उन्होंने ये निचोड़ निकाल के बताया कि जो सेक्शन 5 सबसेक्शन 18 सबसेक्शन डी है, वो उस तरह के लीज अरेंजमेंट्स को कहता है कि जो कैपिटल लीज है या फाइनेंशियल लीज है, नॉट ऑल टाइप ऑफ लीज. आपकी जो लीज है, दिस इज एन ऑपरेशनल लीज. You gave land for the purpose of construction of some flat therein. Not for, you did not give the, disperse something to them. जो आपने लैंड दी दिया थी उसकी ऑनरशिप कुछ टाइम तक, यानी कि पर्टिकुलर लीज पे दी हुई है आपने, ऑनरशिप पे दे दी हो. तो जब ये एक फाइनेंशियल या कैपिटल लीज नहीं है, तो वी कांट टर्म इट एज ए, वी कांट ट्रीट यू एज ए फाइनेंशियल क्रेडिटर. मीनिंग देयर बाय कि इस तरह के एग्रीमेंट्स के अंदर, बिकॉज होम बायर्स के अंदर इस तरह के थिंग्स डू अराइज वेरी यूजली, तो उन्होंने डिसबर्समेंट को देखा. उन्होंने कहा जी डिसबर्समेंट में अगर मनी है, जब मनी से वेरी क्लोज को कोई चीज है, तो देन वी कैन ट्रीट यू एज ए फाइनेंशियल क्रेडिटर, नॉट अदरवाइज. So they, I mean to say, they went with the contention of the CD and treated it as treated Node Authority as OC, not as a FC. Now I move to my fourth judgment. I have total 7 judgments to share with you. This I've chosen this judgment. This is Shri Babu A. Damnagari and another versus Union of India. This is a Karnataka High Court judgment. Actually, what is happening is that कि एक बड़ा फेमस केस उस समय चल रहा है हमारे यहाँ पे सुप्रीम कोर्ट में, गुरमीत सिंह सोधी का. गुरमीत सिंह सोधी के अंदर जैसे हमारे यहाँ पे ललित कुमार जैन का पहले केस की इंटरप्रिटेशन सुप्रीम कोर्ट ने ली थी, एंड ये जो, यानी कि जो पर्सनल कंट्रोल अगेंस्ट है, ये वैलिड है नहीं वैलिड है, ऑल दिस थिंग. तो ये अब वो तो केस खत्म हो गया, एडजुडिकेट हो गया. अब उसके बाद अब गुरमीत सिंह सोधी का केस चल रहा है, जिसके अंदर ये चैलेंज करा गया कि जो हमारे सेक्शंस हैं पर्सनल कंट्रोल वाले, जो हमारे क्या कहते हैं पार्ट 4 के अंदर आई थिंक आते हैं, तो ये जितने भी सेक्शंस हैं, ये इसके अंदर क्या कहते हैं जस्टिस नहीं किया जाता विद द पर्सनल कंट्रोल. बिकॉज जैसे ही आपको पता है कि इसमें सेक्शन 94 या सेक्शन 95 के अंदर जब हम एप्लीकेशन फाइल करते हैं, तो 94 में तो चलिए वो पर्सनल कंट्रोल खुद करता है. 95 के अंदर जैसे ही फाइनेंशियल क्रेडिटर जब और क्रेडिटर कोई एप्लीकेशन फाइल करता है, तो इट इज सेड दैट की जो सेक्शन 95 है, it violates the fundamental right as granted to an individual under Article 32 of the Constitution, whereas whereas an application is filed against him without asking him and without taking a reply from him. These sections should be treated as ultra vires of Constitution and not valid. तो but ये मैंने आपको तो सारी कहानी बताई. ये गुरमीत सोधी का केस के अंदर सुप्रीम कोर्ट में चल रहा है, तो उसमें ये हो रहा है कि जो भी बंदा अगर अपनी उनके अगेंस्ट अगर 95 की एप्लीकेशन फाइल हुई पड़ी है, तो वो अपनी उसके अगेंस्ट स्टे ले लेता है फॉर हिज ऑल 95 एप्लीकेशंस. बट ऑनरेबल कर्नाटका हाई कोर्ट हैज गॉन अगेंस्ट इट. दे सेड दे हैव कैंडिडेटली हेल्ड दैट ये जो सेक्शन है 95, 1, 99 and 100 of the code, they said that under this section only limited power has been given to the RP कि वो एक रिपोर्ट बनाए और कोर्ट को सबमिट करे. जब कोर्ट के पास रिपोर्ट आती है, तो उसमें कोर्ट पर्सनल कंट्रोल से पूछता है कि भैया ये जो रिपोर्ट आई है, इसके अगेंस्ट आपको क्या ऑब्जेक्शन है, शुड वी एडमिट एप्लीकेशन अगेंस्ट यू और नॉट. तो जब ये एक सेफगार्ड उस समय दिया जाता है उस समय, तो मीनिंग देयर बाय दैट दे हैव हेल्ड all these sections as valid. We have taken this case to discuss here is that only for the reason this is going against the thought of the Honorable Supreme Court in the case of Gurmeet Sodhi, जो कि 29/4 का जिनका ऑर्डर था. So I thought of sharing with you. See the interpretation issue. One High Court is going against or having a divergent view of Honorable this thing. Now I move to my 5th case. This is G. Ratan Lalova versus Indian Overseas Bank. What happened is that we have seen this thing in our tax practice also. What happened in this case is that the applicant went to the Honorable High Court, and Honorable High Court said very emphatically कि जब आपको आपकी जो भी ग्रीवेंस थी उसके अगेंस्ट एक एपलेंट मैकेनिज्म आपके पास है, तो पहले आप उसको एक्सरसाइज करिए. अगर एपलेंट मैकेनिज्म किसी पर्टिकुलर एस्पेक्ट के अगेंस्ट नहीं है, then you come to us. This happened in our taxation matters also. People thought of getting relief by immediately going to the High Court when they expect that no such relief will be granted either by the CIDP or ITIT. So they said कि जब आपके पास एक पर्टिकुलर ग्रेवेंस के लिए एक एपलेंट मैकेनिज्म है, यू फर्स्ट एक्सरसाइज देन टू देम ओनली एंड देन कम टू अस। तो मीनिंग देयर बाय कि वी शुड, यू नो, दिस इज अ लर्निंग लेसन फ्रॉम अस आल्सो, कि हर केस के लिए हम वी शुड नॉट गो टू द हाई कोर्ट, जो एपलेंट मैकेनिज्म है दैट शुड बी फर्स्टली एक्सरसाइज। ये सेक्शन 6 की मैंने ये एनसीईआरटी की जजमेंट है, ये मैंने इसलिए इसको रखा कि इस केस में इट्स अ वेरी स्मॉल जजमेंट। व्हाट हैपेंड कि जब वो ऑनरेबल एडजुडिकेटिंग अथॉरिटी एप्लीकेशन को एनालाइज कर रही थी, तो दे फाउंड सम डिस्क्रिपेंसीज देयर। सिन नंबर सेल्स बिल पे नहीं था, कॉन्ट्रैक्ट नोट पे वायलेशन नहीं था, तो दे सेड कि दिस इज अ वायलेशन ऑफ सेक्शन 12 सबसेक्शन 3 सबसेक्शन सी ऑफ द कंपनीज एक्ट ऑफ 13, और मीनिंग देयर है कि ये जो recorder सारा fabricated है, they impose 1 lakh rupees cost on the on the applicant also. So what I mean to say is that whenever we file section 9 application, sorry, not section 7, section 9 application, we should be very cautious about the document. अब तो वैसे भी काफी सारी चीजें और आपको देनी पड़ रही है। अनंत मूर्ति वर्सेस सोनी इंफ्राटेक प्राइवेट लिमिटेड। This is again a very a unique case of a home buyer. I just give you the background of this particular case. What basically happened, as usual, एक होम बायर ने 31 लाख रुपए स्विगी से लेना था, तो वो उसको मिला नहीं, तो वो सेक्शन 7 की उसने एप्लीकेशन फाइल कर दी। और जब उसने सेक्शन 7 की एप्लीकेशन फाइल कर दी, तो जो सीडी या उसके डायरेक्टर जो भी था, उन्होंने सेक्शन 12A के अगेंस्ट उनसे सेटलमेंट कर ली और उसको पेमेंट कर दी। बट इन द मीन टाइम केस जो था, एनसीएलटी ने उसकी एप्लीकेशन एडमिट कर ली, सीडी या उनके डायरेक्टर वेंट टू द एनसीएलटी, एट दैट टाइम केस वाज पेंडिंग बिफोर द एनसीएलटी। तो एनसीएलटी के पास आई हैव यू मस्ट बी हैविंग एक्सपीरियंस आल्सो, कि जब एक इस तरह की एप्लीकेशन आती है, तो जो बाकी होम बायर्स होते हैं वो भी एप्लीकेशन डाल देते हैं कि वी आल्सो वांट आवर मनी शुड बी रिटर्न्ड और लाइक दैट करके। तो बट जो एनसीएलटी थी, उन्होंने क्रिप्ट जो था इसका एडमिट कर लिया ऑन द बेसिस कि ये जो है, क्या नाम इसका, आई थिंक अराउंड 452 थे इसके अंदर होम बायर, या 452 वाला होम बायर। तो दे सेट की बाकियों की ग्रेवियंस है एंड लाइक दैट करके। बट दिस डायरेक्टर और सीडी आर वेरी स्मार्ट। व्हाट इट डिड, he has a meeting with all the buyers and entered into an agreement with them. He said कि मैं 2-3 बातें उसने जो भी होम बायर्स है उनको ये केस समझाई कि मैं आपसे कोई कॉस्ट एस्केलेशन नहीं लूंगा, मैं आपकी जो है फ्लैट आपको विद इन दिस पर्टिकुलर पीरियड बना के आपको दे दूंगा, और the all this thing. So this plea he took in front of the Supreme Court also. The Honorable Supreme Court, quashed the NCLT order of CRIP on the ground that if CRIP is started against this particular CD, तो जो home buyers are, they will be the very big sufferer, because CRIP के बाद उनको फ्लैट कब मिलेगा कब नहीं मिलेगा, तो कॉस्ट भी एस्केलेट हो जाएगी। तो इस करके थिंग्स आर देयर। तो ये केस मैंने इसलिए चुना, if we have any home buyers problem whereby facts we can correlate or facts are falling approximately to this particular case, so we can get relief against scrape if you are representing CD there, or if you are representing home buyer, we should be cautious कि हमने इस तरह की मालिक एप्लीकेशन हो जाएगी। Okay, now those are all my judgments जो कि पिछले हमारी लास्ट मीटिंग हुई थी उसके बाद से लेके अब तक के बीच में important थे, which I thought of sharing with you. Now I have very 2 or 3 small issues before I'm acting as a stumbling block for Mr. Sumit. तो सुमित जी के लिए फिर हम इमीडिएटली स्टार्ट कर लेते हैं। जैसे कि आज थिंग्स आर सो फास्ट। मैंने पहले यहाँ पे अपनी प्रेजेंटेशन में लिखा था कि आईबीबीआई की साइट के अंदर जो फॉर्म्स वगैरह हैं वो प्रॉपर नहीं आ रहे, लेकिन आज मैं जैसे ही सुबह उठ के मैंने उसको देखा, तो दो ऑल फॉर्म्स हैव बीन प्रॉपर। आईबीबीआई साइट हैज बीन रीवैम्प्ड टुडे। सिमिलरली अनदर थिंग आई सी, जैसे कि आप हम सब लोगों को पता है कि नए चीफ जस्टिस आए हैं, यूजू ललित जी, तो सुप्रीम कोर्ट की जो प्रोसीडिंग्स है वो लाइव स्ट्रीमिंग होगी। हमारा अगर कोई इंपॉर्टेंट इंटरेस्टिंग केस है आईबीसी का जो सुप्रीम कोर्ट में चल रहा हो, तो दैट यू कैन सी लेटर ऑन लाइव आल्सो। तो आई थॉट ऑफ शेयरिंग इट विद माय प्रोफेशनल प्लीज। दूसरा एक नया इश्यू आया है the ROC may visit your registered office also if they have any doubt. Rule 25B and Rule 25C has been amended. So although we are an RP and responsibility legislators also for maintenance of proper registered office. तो सब आरपीस को मेरी ये रिक्वेस्ट है कि एज पर दिस पर्टिकुलर रूल की मिनट्स जो कि है वो दाएं बाएं जो भी है वो प्रॉपर वैसे रख लें, नाम प्रॉपर रख लें, सिन नंबर वगैरह प्रॉपर नेम प्लेट के नीचे रख लें. तो now RSC has got power to inspect the premises. Okay. The third thing is that the IBC has come out with they want to appoint some research associate. अगर हमारी हम लोग तो खैर नहीं एलिजिबल यानी कि इंटरेस्टेड होंगे, जो हमारे एम्प्लॉइज के अंदर जो एम्प्लॉइज भी हमारे यहाँ उनके पुलिस वगैरह हो तो दे कैन विजिट IBC साइट एंड गेट दिस थिंग देयर. तो दैट इज ऑल. हाँ, एक छोटा सा मेरे माइंड में एक्साइटमेंट थी कि मैं लेट मी सी टू इट हाउ मेनी IPs आर देयर. तो आई सर्च एंड फाउंड दैट 95 IPs are there. So in this way, this is all I have today for me. Navneet ji, यही है मेरा सारा कुछ. Now thank you very much for giving me opportunity of sharing my presentation with you. Now please.
थैंक यू मनोज जी. थैंक्स अ लॉट मनोज जी. आपका इतना बढ़िया प्रेजेंटेशन लगता है कि भी आप करते रहें, क्योंकि नई नई चीजें पता लगती रहती हैं, केस लॉस भी पता लग रहे हैं. डेवलपमेंट IBPA के साथ हमारी मीटिंग हुई, उसके बारे में भी आपने पूरा बताया. और नई लेटेस्ट डेवलपमेंट आपने जो बता दी कि वेबसाइट रिवैम्प होगी एंड लाइव स्ट्रीमिंग इज आल्सो अवेलेबल. ये ऐसी चीजें जो हम सभी के लिए जरूरत की चीजें. एंड यू ऑलवेज कीप एवरीबॉडी अपडेटेड ऑफ ईच एंड एवरीथिंग. ये एक सबसे ज्यादा अच्छी चीज जो हमें लगती है कि आपको सुनने का इसीलिए दिल करता है कि चलो ठीक है, हमेशा नई नई चीजें पता लगती रहेंगी. बिकॉज इट इज वेरी डिफिकल्ट फॉर एनी प्रोफेशनल कि भाई वो हर चीजों को देखता रहे, कहीं जाके केस लॉज भी पढ़ता रहे, इतनी सारी जगह जाना, केस लॉज पूरे ढूंढ के लाना जो रेलेवेंट है एंड हम लोगों को उनके बारे में बताना, ये अपने आप में एक बड़ी अच्छी चीज है. थैंक्स अ लॉट फॉर दैट मनोज जी. आप आईपा को बड़े अच्छे तरीके से इस तरीके से आईपा को आगे लेके जा रहे हैं कि सारे IPs के लिए आप काफी अच्छी चीजें इकट्ठी करके सभी को बताते रहते हैं. एंड थैंक्स अ लॉट मनोज जी. नाउ आई वुड रिक्वेस्ट सुमित सर. सर, वी आर ईगरली वेटिंग फॉर यू. जस्ट वांट टू नो कि भाई अभी आज की डेट में जो हमारा स्पेसिफिक सेशन है, हाउ डू यू टेक दैट अलोंग विद अस, एंड वी आर लुकिंग फॉरवर्ड to learn more and more from your session, sir. Over to you.
No, thank you very much. Thank you, Manoj ji, Navneet ji, and Khurana ji, and all the other office bearers of IIPA. My good friend Siddharth Sharma has also joined. So, good evening to everyone, and thank you for this opportunity. Sir, मुझे वो screen share का option.
Sir, आपको मैंने co-host बना दिया तो आप screen share कर सकते हैं.
अच्छा.
You are already co-host.
But मेरे को I think हाँ now yes right. Yeah. So is my screen visible?
Absolutely visible.
Yes, sir.
Right. Right. Thank you. So first of all, thank you very much, IIPA, for giving me this opportunity. Today, the topic of deliberation which has been given to me is the sale of CD as a going concern. And I would be basically talking about the history of this particular provision, why it was introduced into the scheme of the Insolvency and Bankruptcy Code, and the related case laws and the current jurisprudence which has emerged as far as this concept of CD as a going concern is concerned. So, as all of you are aware that probably India is the first country which provides sale of CD as a going concern under the liquidation mode. Because when this law was basically made part of the IBC, people who were practicing in this area from different countries were sort of surprised. And even the professionals in our country, most of us were not coming to terms that how can sale of CD as a going concern be permitted under liquidation. And let me tell you that the liquidation regulation, when it was drafted, it also never envisaged this particular option. So there were a lot of discussions, etc. And thereafter, the regulator thought that, yes, this should be the way forward. And in fact, let me also share with you, because most of us over here are belonging to the field of chartered accountancy and cost accountancy or company secretaryship. And most of us were not actively engaged into the winding up related affairs of the companies, because that was primarily the domain of the advocates. So if you go through the winding up related various case laws of high courts and Supreme Court, you'll surprisingly find that there are many such instances where in the winding up regime, the sale of a company which was under winding up has also been allowed and permitted. At that point of time, many judgments you'll find wherein slump sale of companies was also allowed by the relevant adjudicating authority under the Companies Act at that point of time. So I feel that, looking at hindsight, it is not a new concept which was introduced under the IBC. It was very much prevalent. But yes, it was further extended to the Insolvency and Bankruptcy Code, because the objective of the code was only revival, and it did not talk about liquidation. So with that background, let me take you to the history of introduction of this provision. So as I mentioned, when this law came, the code as well as regulations did not contain any such provision of the going concern sale. First, it was introduced by liquidation order dated 11th January 2018 in the matter of Gujarat NRE Coke Limited. And let me also take you through the rationale for allowing going concern sale in the GNCL liquidation order. So when we are talking about Gujarat NRE Coke Limited, I was the resolution professional, and there was a plan which was submitted, but which was not approved by the committee of creditors. So 1 or 2 days prior to the end of the CRP process, when the voting took place, and the voting rejected the plan which was submitted by one particular RA, immediately workmen and employees submitted a plan. But then, we did not have enough time. The plan was submitted by the workmen and employment, if I remember correctly, on Saturday late night. And on Monday, there was a hearing before the tribunal. And the Monday, which was 1st January 2018. That was the last date of the CRP of Gujarat NRE Coke Limited. So the entire matter was heard on 1st January. And then, it was further adjourned for 2 or 3 other hearings. And finally, on 11th January, the court passed the liquidation order. And what was represented before the tribunal so that this liquidation order was passed? CD was functional and its plant were operating. It was also making operating profits. In fact, there was operating profits in the previous 2 quarters prior to when the liquidation order was announced. It was also paying salaries and wages to employees and workmen whose livelihood was dependent upon the corporate debtor. The employees filed affidavit during the course of hearing stating that regulations permit slump sale. And if you remember, at that point of time, Regulation 32 prescribed certain mode of sale, and slump sale was one of the options which was also prescribed there right from the day 1 of the promulgation of the code. And so the employees argued that a slump sale method is already provided in the code, and therefore going concern sale should be allowed. And the example which they presented before the court was that as per the income tax law, slump sale means transfer of one or more undertaking as a going concern on a lump sum consideration without individual value being assigned to the assets. And they also highlighted the fact that the apex court had in the past, as I was telling you, under the winding up regime, it had allowed going concern sale in extraordinary circumstances. And the case law is Allahabad Bank versus ARC Holding 2001. So based on this premise and this representation and this thought, the liquidation order of Gujarat NRE Coke was passed with a direction that the liquidator who will be appointed would try to sell the company as a going concern for an initial period of 3 months, at a reserve price which was fixed by the tribunal. And thereafter, if there is no such going concern happening, then the liquidator will proceed to sell the company under the normal and other mode of sale which is prescribed in law.
सुमित जी, एक छोटी सी रिक्वेस्ट थी आपको। ये आपका जो व्यू आ रहा है ना, ये इसका क्या कहते हैं प्रेजेंटेशन का, इसको आप अगर फुल स्क्रीन व्यू कर पाए तो दैट विल बी लुक वेरी नाइस। यस, दिस इज देयर।
हाँ, मैंने कर दिया।
यस, आप बहुत अच्छा लग रहा है देखने में।
राइट, सॉरी, या, नाउ इट्स ओके, या,
एब्सोल्युटली ओके।
थैंक यू,
मोर ब्यूटीफुल,
थैंक यू। So effective 1st April 2018, Liquidation Regulation 32 was amended to include selling of a CD as a going concern. So I remember very clearly when this Gujarat and Hari Coke Limited order was passed, immediately, it spread like a fire in the entire IBC industry, and immediately the think tank of the Insolvency and Bankruptcy Board called various meetings and examined this possibility. And at that point of time, many insolvency professionals and many advocates were also called for a meeting as to evaluate that whether going concern sales should be also made part of the regulation. So Dr. Sahu conducted a lot of meetings, and during this meeting, it transpired that yes, going concern sales should be an option, and therefore from 1st April 2018, Liquidation Regulation 32 was amended. For the first time, the liquidation process regulation was amended after 4 months to include selling of CD as a going concern also as an option under Regulation 32. Thereafter, we had a lot of roundtable discussions in the Insolvency and Bankruptcy Board, and wherein second amendment, which was actually a precursor to the second amendment in the liquidation process regulation, and this happened on 22nd October 2018, which basically largely captured the discussions which held at the various IBBI meetings with the liquidator and other stakeholders. So the most significant introduction was the concept of sale of business of the corporate debtor as a going concern. So sale of corporate debtor as a going concern was by way of the order of Gujarat and Hari Coke, and it got notified with effect from April 2018, and thereafter, after around 6 to 7 months of various discussion, it was also decided that apart from sale of corporate debtor as a going concern, sale of business of the corporate debtor as a going concern would also be introduced as one of the options. So the minutes dated 26th June 2018, which is available on the IBBI website still, it captures the relevant discussion, which was relevant. And this particular discussion has also been relied by various adjudicating authority while passing the order for going concern sale. And we will discuss that with some examples. There were the discussions relevant to going concern sale is reproduced in the subsequent slide. So this is basically the gist of the discussion which happened in the various IBBI meetings. So what was discussed and decided is that CD may be sold as a going concern as provided in the extant regulations. As the company survives, there will be no need for dissolution of the company in terms of Section 54 of the code. The asset along with the attendant claims, limitation, licenses, permits or business authorizations remain in the company. The company survives as it was. The ownership of the company is transferred by the liquidator to the acquirer. So this would basically form the premise of the GCS, that is the going concern sale. Now, the biggest roadblock, I was also present in a couple of meetings, and my view was that the biggest roadblock was the provision of Section 54, which said that the liquidation process will only be over once a dissolution order is passed. So in case of GCS, the dissolution order could not have been passed because the company had to change hands, and that was the concept of going concern sale. It could not have been wounded up. So the provision of Section 54, which was basically passed by the Parliament, was seen as a roadblock. And then, subsequently, in order to come out of that roadblock, regulations were amended, wherein it was basically decided, and the regulations thus prescribe that whenever a company is sold as a GCS, instead of filing a dissolution order, the liquidator is required to file a final report, and that would be good enough. So that is how Section 54 was also further amended. So the IBBI roundtable discussion also discussed about the mode of sale of the CD of the intended buyer as a going concern. How should the transfer of shares of the CD take place to the intended buyer? How will the transfer of going concern of the CD will take place to the buyer if there is any other scheme which is proposed by the buyers? What would be the continuation of the authority, powers, and obligations of the liquidator to complete the liquidation process as provided under the code and the regulations, including the control, operations, and continuation of the liquidation bank account of the CD? How will be the payment of stakeholders in accordance with Section 53 from the liquidation bank account be met? And what protection will the intended buyer will get from all the claims and liabilities pertaining to the period prior to the sale of the CD as a going concern, which was very, very important. So all these things were discussed, friends, but never made part of the regulations. I don't know why, but yes, IBBI officials at that point of time perhaps thought that there's no requirement to put this process as a part of the regulations. Let the code or let the process take its own course, and probably they thought that the adjudicating authority will decide the subsequent course of action whenever the CD is sold as a going concern. But wherever we have made representation to IBBI, we still feel that at least the process of going concern sale should be made part of the regulation, should be codified, so that there's no element of surprise, and the amount of litigation which we are seeing in case of GCS, the amount of time which gets consumed in completing the GCS gets reduced to a significant extent. So the need of the hour is that it forms part of the regulations at least. But then, it is up to the wisdom of IBBI to take a call. So yes, 45.3, as I told you, was also amended, keeping in view the provisions of Section 54. So effective 22nd October 2018, Liquidation Regulation 32 was further amended to include sale of business of the CD as a going concern. Let us also look at Apex Court's order dated 25 January 2019. The Honorable Supreme Court observation on going concern sale. What is interesting to note that the preamble does not in any manner refer to liquidation, which is only availed of as a last resort if there is either no resolution plan or the resolution plans submitted are not up to the mark. Even in liquidation, the liquidator can sell the business of the corporate debtor as a going concern. In ArcelorMittal Private Limited versus Satish Kumar Gupta, at paragraph 83 footnote 3, it is mentioned, the Honorable Supreme Court noticed that Regulation 32 of the Insolvency and Bankruptcy Board of India states that the liquidator may also sell the corporate debtor as a going concern. So the Apex Court also noted the regulations and the prescription in the regulations permitting the GCS, and probably upheld that piece of regulations, because it very clearly mentioned that even the preamble of the IBC does not talk about liquidation, and hence revival should be the first task of the resolution professional or the liquidator. Liquidation amendment regulations were also issued on 25th July 2019 subsequently, and these amendments specified the process for sale of CD as a going concern and sale of business of CD as a going concern under liquidation by way of introduction of Regulation 32A. Now, let me tell you, it was just a process so that a decision of going concern sale can be taken once the CRP of the company fails. But the nitty-gritty is how the company would be transferred, what are the reliefs and concessions, whether exemptions are anywhere to be granted. All these things were not codified and are still left to be codified. So what was the amendment regulation all about? It provided that when a CD is sold as a going concern, the liquidation process shall be closed without dissolution of CD as a going concern, and then liquidator to first endeavor for going concern sale if recommended by the committee of creditors, or if the liquidator is of the opinion that going concern sale shall maximize value. So whenever a company goes into liquidation, the first duty of the liquidator is try to sell the company as a going concern sale, if recommended by the committee of creditors. So what happens, friends, is that now, because of the amendment regulations in the liquidation process regulation and the CRP regulation process, if they are to be read in sync with each other, so the scheme of the code now is that whenever a company's CRP does not result in any successful resolution plan, so the company ought to go into liquidation. So before going into the liquidation, the committee of creditors will evaluate and would recommend that while this company's liquidation order is passed, this going concern sale or sale of business as a going concern sale should be attempted. So, and if that is provided, then the liquidator, whenever he takes charge, the first attempt he is required to make is to ensure that he tries both the options. Even if the COC fails to recommend, and if the liquidator feels that no, there is an opportunity for reviving this company by way of going concern sale, then he shall take the steps under regulation 32E and F, that is going concern sale and going for business sale, if he feels so. The regulations also provide that when the committee of creditors are recommending a going concern sale, then they shall also opine on the group of assets and liabilities, or they shall identify the group of assets and liabilities which should be sold as going concern sale. And if the COC does not do that, it is also open to the liquidator, if he feels so, to bucket to bucket a group of assets and liabilities to be sold as a part of going concern sale. And if the GCS is a failure, then he will proceed for other mode of sale. So this is also provided in the liquidation amendment regulation and the CRP regulations also. And let me just take you through the CRP amendment regulations. Both CRP second amendment regulations 2019 and liquidation second amendment regulations 19 were notified on 25th July 2009. So here the amendments require that while approving a resolution plan or deciding to liquidate the CD, the COC may recommend sale of the CD or sale of business of a CD as a going concern if an order for liquidation is passed by A. And where the committee recommends sale as a going concern, it shall identify and group the assets and liability, which according to the commercial consideration ought to be sold as a going concern under liquidation. RP shall submit the above recommendation to the committee to the AA while filing the approval or decision of the committee as the case may be. So this is what we have discussed, and these are the regulations which are there in front of you. Till 30th June 2022, around 18 corporate debtors in liquidation process were sold as a going concern, and few more are waiting orders from adjudicating authority. So what are the key benefits of going concern sale? Of course, it preserves employment. It provides higher returns to the stakeholders. Timely completion of the liquidation process. Yes, that is a key benefit which is envisaged, but we have seen a lot of regulatory delays in the going concern sale. And I'm sure that the authorities are keenly looking at this aspect, and probably things would settle so that the liquidation process could be completed within time. Saving the viable companies from liquidator, yes, that is the whole objective of the code, because revival is the key, and that is why going concern sale is being promoted. Saving loss of revenue by avoiding premature liquidation is also one of the key benefits of going concern sale. Cost savings and faster realization. So all these things put together definitely point for a favorable case for a going concern sale. But yes, as professionals, we are aware of the regulatory hassles still which we are facing, and I'm sure in times to come all these things would be taken care of. Meaning of going concern, very, very important. Wherever you go or wherever we think and open our textbook, we often try to ponder that going concern sale has not been defined under the insolvency and bankruptcy code. So how should one interpret the going concern definition? So it is open for interpretation, but then transfer of business as a going concern is a well-known concept. We as professionals are very much aware that whenever demerger of an undertaking happens, it usually happens by transferring existing undertaking into a new company on a going concern basis. And all of us who have seen the demerger orders passed by the tribunal would have come through this concept quite often. In KBD Sugars and Distilleries Limited, Bangalore versus Assistant Commissioner of Income Tax, it was held that going concern always means to stay alive, whether profit making or not. Undertaking constituted a business activity capable of being run independently for the foreseeable future. This is as per Hindustan Engineering by IIT Kolkata in 2013. The general judicial impression of going concern sale is that the employees will be passed on to the acquirer. All the assets tangible, because see, if you go through the jurisprudence, the previous case laws of Apex Court and High Court, often you will find that why going concern sale has been upheld. One of the prominent reason is the continuance of the job and employment of the workmen and employees. This has been one of the most paramount reasons for upholding the case of going concern sale even in the past. Now, of course, in IBC, it is about revival of the company, but then revival of the company is also about benefits of the continuous employment to the employees and workmen, apart from other social benefits which it brings to the table of the economy. All the assets, tangible, intangible resources needed to continue to operate independently, a business activity, which may be whole or part of the business of the CD, without values being assigned to individual asset or resource. This is the definition of going concern sale as per IBBI discussion minutes dated 26 June 2018. As per Accounting Standard 1, the enterprise is normally viewed as a going concern, that is, as continuing in operation for the foreseeable future. It is assumed that the enterprise has neither the intention nor the necessity of liquidation or of curtailing materiality the scale of the operation. So this is the going concern definition of as per Accounting Standard 1. And if you see the Insolvency Law Committee report 26 March 2016, going concern sale implies that CD would be functional as it would have been prior to the initiation of CIIP, other than the restrictions put by court. So these are some of the definitions which I have captured so as to give you a sense as to what going concern means. What I feel is that to whichever definition you look at, the idea is basically the revival, and the code basically promotes revival, and that should be the key parameter for consideration for any committee of creditors or liquidation when they are dealing with a company under liquidation if the CRP has failed. In Gaurav Jain versus Sanjay Gupta, liquidator of Topworth Pipes and Tubes Private Limited, it was noted by the adjudicating authority that even though there is no specific provision in the code for going concern sale, the liquidation process regulations provide guiding principles in dealing with the case. It held that by guiding principles, because it talks about 32(1)(e) going concern sale and sale of company as a business, sale of business of the CD as a going concern, and also with the introduction of regulation 32A, the introduction of the regulation which talked about the process, both the CRP regulations and the liquidation process regulations. So the adjudicating authority noted that yes, the code may not specifically talk about the going concern sale, but yes, regulations have touched upon the going concern sale, and hence it should be considered. And the same was also held by the Apex Court when we just discussed earlier. It also held that the going concern sale in normal parlance is transfer of assets along with the liabilities. However, as far as the going concern sale in liquidation is concerned, there is a clear difference that only assets are transferred and the liabilities of the CD has to be settled in accordance with section 53 of the code, and hence the purchaser of the assets takes over the assets without any encumbrance or charge and free from the action of the creditors. Very, very important point which was noted by the adjudicating authority. Of course, there were some aberration because NCLAT in one of the cases took a different view, and thereafter the same bench issued a clarification by way of another order, not clarification to be precise, but yes, probably this view again prevailed. And so what we feel is that yes, probably the bench might have rethought about its previous order and thereafter sort of rectified its position. So I will discuss that order, both the orders with you. So now the law is settled as of now, very, very clear. The object of the code is also very, very clear, that going concern sale, if the liquidator or committee of creditors, they decide to identify assets and liability and make it as a part of going concern sale, it's fine. But if they are only wanting to put the assets under going concern sale, that is also acceptable. And what would happen to the liabilities? The past liabilities would be dealt in accordance with section 53 of the code. And if anything remains unpaid, all those liabilities would get extinguished. And that is the import from the section 53 of the code. And if there are present liabilities, which means liabilities which are unpaid during the CRP process and the liquidation process, those would definitely have a priority and again would have to be dealt in accordance with section 53 of the code. So the buyer of the asset, if the going concern sale is approved, would get clean slate as directed and upheld by Supreme Court in Ghanshyam. The legal entity of the corporate debtor survives, and the assets with claims, limitations, licenses, permits, or business authorizations remain with the corporate debtor. Only the ownership of the CD is acquired by the successful bidder, and all creditors of the CD gets discharged. This is also a very important and vital point noted and observed by the adjudicating authority in this particular case. Yeah. So upholding the regulation 32A, validity of regulation 32A, which was introduced on 25th July 2019, NCLT Principal Bench in Invest Asset Securitization and Reconstruction Private Limited, Mohan James, held the regulations permitting the liquidator to attempt going concern sale are inconsistent with the code and rules issued under section 239 of the code. The tribunal noted that after the liquidation, there is a requirement of dissolution of the CD, which would not be complied in case of going concern sale of CD. So, this decision was again, turned, was basically negated, and Honorable Anklet in Mohan James, by its order dated 24th August 2021, held the validity of the regulations permitting the liquidator to attempt going concern sale of corporate debtor as valid. So all of you must have heard, and there was a lot of news in the newspaper, that because of section 54, the going concern sale has become a challenge. But the regulations do provide for going concern sale, and the same was also upheld by Honorable NCLAT. This was basically on the premise that when the Parliament has passed a law wherein section 54 says that the liquidation will come to an end only after dissolution, so the regulations cannot override the intent of the legislation, and hence the rules and regulations issued under section 239 of the code by IBBI are not to be considered. But then this particular view of principal bench was overturned, and Anklet held that yes, GCS is valid. Honorable Anklet also further said that having regard to the fact that the code does not prevent the closure of liquidation process in the instance the corporate debtor is sold as a going concern pursuant to regulation 32E, following a closure report filed under regulation 45(3)A of the liquidation process regulations, it would be contradictory to observe that closure of liquidation proceedings cannot be done and only dissolution is provided for under the code. This would demolish the very spirit and objective of the code it can be safely construed that before the completion of section 270 days, if no decision under regulation 39C is taken by the COC, only regulation 32A is to be followed. Honorable NCLT Hyderabad bench in Bank of India, and this is going concern sale has been allowed by various NCLT. Very, very interesting decisions, which will basically give you a sense as to when going concern sale is allowed, there are certain exemptions and privileges which is expected by the buyer who wants to acquire the assets, and such exemptions and privileges, whether it can be granted, whether NCLT has got the power to grant those exemptions and privileges, everything is being discussed by way of various orders, and these are very interesting orders, which I'm sure that all of you will enjoy listening and reading to it. So in Southern Online Biotechnologies Limited, which allowed going concern sale of a CD, it was also held that regulation 32 of liquidation regulations provides for going concern sale. The object of the code is not for liquidation but for resolution. In the instant case, the unit was sold as a going concern, which is more or less in the nature of resolution of the corporate debtor. The applicant came forward for purchasing the unit as a going concern. The mere purchase of the unit as going concern without granting certain reliefs that would be essential and necessary to run the business as a going concern is of no use. So NCLT Mumbai in Gaurav Jain and Sanjay Gupta also allowed going concern sale and noted that even though there is no specific provision in the code regarding sale of the company as a going concern, IBBI has formed liquidation process regulation under the code, and we have to take them as guiding principles in dealing with the case. So I hope you are now trying to understand the interplay. The courts have tried to establish the interplay between the provisions of the code and the regulations. Earlier, there was a divided opinion that yes, if the code is not providing for going concern sale, it is only the liquidation regulation which is providing for going concern sale. But now that divided opinion has been bridged by various decisions of the adjudicating authority. In T. Raja Kishore versus VNR Infrastructure, where going concern sale was allowed, it was held that object of the code is not liquidation but resolution. And so it is essential to note that mere sale of CD as a going concern without granting the consequential reliefs that are necessary to run the business as a going concern would be meaningless. One of the major advantage of sale of the corporate debtor as a going concern is that the corporate remains a legal entity, it will not be dissolved, and the CD will be transferred along with the assets. So what are these reliefs and concessions? Why these reliefs and concessions? So friends, the code, the regulation and the code is silent. The code in fact does not talk about going concern sale. Regulation talks about that. It has been upheld that both are in sync. Now, what are the reliefs and concessions when a GCS happens? First relief, how will the transfer of corporate debtor take place? So in case of a resolution plan process, it is very, very clearly stated that the resolution plan will be approved by an order of the adjudicating authority, and that order of the adjudicating authority would be binding on stakeholders. What does the order normally says? It brings the company, it transfers the company to the resolution applicant on a clean slate by very clearly saying that these are the liabilities would be settled as per the approved resolution plan. All other liabilities would be extinguished. So is there any similar provision in the liquidation process regulation where a company is sold as a going concern? No. So there are various other reliefs and concession which any resolution applicant or an acquirer would like to have. For example, there are exemptions granted under the resolution process for approval of the stakeholders. Say, for example, if a resolution plan is proposing merger or demerger as a part of resolution plan, or sale of major undertaking to another company as a part of resolution plan, the Companies Act requires that approval of the shareholders is required. Or if there is any fresh issue of shares, the Companies Act requires that it would require approval of the shareholders of the company. So all those approvals are not required because there is a provision in the CRP, in the code, which exempts the resolution applicant to obtain specific approval if the resolution plan is approved. So whether similar such exemption is there as a part of liquidation process regulation when a company is sold as a GCS under liquidation? No. So there are certain reliefs and concessions which becomes essential for the acquirer to have when he is acquiring the company as a going concern sale, even under the liquidation process regulation, for which there is ample provision in the code for under the CIRP mode, but for liquidation process, there is no such clarification or provision in the code. So that is why the courts and the tribunal or the adjudicating authority thought is necessary that let us also provide reliefs and concessions which can be granted by us to enable the buyer to complete the acquisition in the proper manner and revive the company, because the ultimate objective is revival. Honorable Supreme Court in case of Arun Kumar Jagatramka, Jindal Steel and Power Limited, by its order dated 15/3/2021, stated that there are three modes in which revival is contemplated under IBC. The first mode of revival is in the form of CIRP. The second mode is when CD or its business is sold as going concern under liquidation. And third is when a revival is contemplated under Section 230 of Companies Act 2013. Honorable NCLT Ahmedabad, by its order dated 8th September 2021, while approving the sale of PSL Limited as a going concern, held that Honorable Supreme Court in Arun Kumar Jagatramka matter has held that the above three modes are similar in nature and the object is also the same. Therefore, the benefits or disabilities attached to one mode of the sale will also be attached to the other mode of the sale of CD as going concern. In other cases also, NCLT, while approving going concern sale, has taken a similar view. So again, coming back to the reliefs and concession. Now it is very clear that since there are three modes of revival in terms of Supreme Court under the IBC, first is the CRP resolution plan, for which there are several exemptions, privileges, which are already provided in the code. Second mode is business to be sold as a going concern, for which liquidation process regulation is silent about any such exemptions, the manner, the process. And third is when the company is revived under Section 230 by scheme of compromise or arrangement. So all these three modes have been considered to be akin to going concern sale, but yes, of course, under different situation. So while granting reliefs and concession, that is where the interplay or the actually the authority of the adjudicating authority is being brought to the light, that whether they can grant reliefs and concessions for GCS under liquidation, just like reliefs and concessions are granted in case of CIRP or Section 230. It has been held yes, because all three modes are with the common objective of revival, and hence the object associated with all the three modes can be interchanged. And that is where we will see that how this has been applied and from which provision the adjudicating authority is drawing their power to issue such order and grant certain reliefs and concessions so as to enable the buyer to have a successful revival of the company under liquidation through GCS. It is more or less in the nature of resolution of CD. Acquirers want certain reliefs that would be essential and necessary to continue to run the business of the CD as a GC. No provision in law for seeking such relief. Realizing the need, some NCLT benches have granted relief and concession even in GCS during liquidation process. NCLT Ahmedabad stated that in principle, the bench agreed with the proposition that certain reliefs and concession can be given in the case of sale of CD as a going concern under liquidation process on the analogy of sale of CD through a resolution plan under CIRP, but the same could be granted only to the extent permissible under IBC. In T. Raja Kishore, it was observed that it is essential to note that mere sale of CD as a GCS without granting the consequential relief that are necessary to run the business as a going concern would be meaningless. It observed that mere purchase of the unit as going concern without granting reliefs that would be essential necessary to run the business as ongoing concern is of no use. In Topworth Pipes, also various reliefs and concessions were allowed. Hyderabad bench in VK Global versus Smart India observed that no doubt the liquidation regulation do not provide granting specific type of reliefs to the applicant. However, when the CD is being sold as a GC, naturally the purchaser is entitled for consequential reliefs to achieve the objective of running the CD as a going concern. Ahmedabad NCLT, while approving PSL India GCS, observed no framework exists in law. NCLT is an adjudicating authority, is under legal obligation to exercise jurisdiction under Section 65 subclause C of the IBC in accordance with the object scheme and structure of the code, which is applicable to both CRP and liquidation proceeding. So if you look at the provisions of subclause C of clause 5 of section 60 of the Insolvency and Bankruptcy Code, it says that we can file an application for question of law or facts or for any other purpose, so that for the purpose of the code, NCLT can pass an order. So NCLT as an adjudicating authority is empowered under this particular provision of the law to pass necessary order in order to ensure the objective of the CRP and the liquidation process enshrined in the code. Honorable Supreme Court has also had the broad objective of the code is revival and continuation of the CD. So considering the broad objective, which is adequate to grant relief, it is imperative for adjudicating authority to look at major similarities between the CD being revived under CIP by way of resolution plan and CD being sold as GC under liquidation. So friends, reliefs and concessions not provided in the law, the adjudicating authorities are drawing the same reliefs and concessions akin to what is being provided under the resolution process, because the entire objective is revival, and whether it's GCS under liquidation or resolution plan under the CIRP, both the end result is identical, and hence even if reliefs and concession related provision is not provided in the code, even if no specific authority, express authority is present in the code, there are various provisions in the code which has been picked up by the adjudicating authority, including the including the jurisprudence which has emerged from the Supreme Court order, and reliefs and concessions have been provided so that the GCS becomes a successful tool. It was observed that modalities of going concern sale under CRP and liquidation remain same, but mode of distribution of consideration is different. That is fine. No specific provision law akin to section 31, which is binding on all the stakeholders in going concern sale under liquidation, but there are no exception or exclusions also in that regard. Regulation section under section 35(1)(n), if you go through the powers of the adjudicating authority under 35(1)(n), it is mentioned that the liquidator may make an application to the adjudicating authority for passing necessary order so as to give effect to the liquidation and CRP objective enshrined in the code. So this is the section which has also been invoked by various adjudicating authority while passing reliefs and concessions and while passing the GCS orders. Once sale is approved under 35(1)(n), read with section 65(c), it becomes binding on all stakeholders. Thereafter, like resolution plan, the implementation starts. So very, very important, the binding nature on stakeholders expressly provided under the CRP, under the code, but absent under the liquidation process. Analogies have and provisions have been invoked under the provision of section 35(1)(n), and also read with section 60 regulation 5 and sub-regulation C. And this is how the objective and the orders are being passed. Reliefs and concession on parallel lines of approved resolution plan can be granted subject to one condition, that such reliefs and concession must be central issue and also in relation to or arising out of the liquidation proceeding of the CD to confer jurisdiction on A under section 65(c) of the code. NCLT is duty bound to provide solutions to various situations which are not specifically provided in the code. NCLT has residuary powers. Very, very important observation. NCLT is duty bound to provide solutions to various situations under the code. 35(1)(n). Go through the provisions and you'll come to know that 65(c). The interplay of these two sections enshrined in the code has been picked up and quite rightly so. So these are some of the reliefs and concessions which have been granted by the adjudicating authority. One in red has not been granted. Approval for sale of going concern, payment of total consideration within X days of GCS approval. So, you know, we all know that liquidation process regulation, whenever we are selling the asset, the time limit is 30 days and extendable by another 60 days with an interest of 12%. So total period of payment is 90 days. But when a going concern sale happens, normally an application for relief and concession is filed by the liquidator or the resolution applicant before the adjudicating authority. And once the going concern sale is approved, then it is said that okay, within the approval, within X days of the approval, the payment would be made. So this by regulation cannot happen. It has to be by order of the adjudicating authority. So such relief or concession has also been granted by adjudicating authority. Rights, title, interest, and assets of the CD to be free from all security, interest, encumbrance, claims, and counterclaims. Again, not mentioned in the code or regulation, but yes, reliefs and concessions to this has been granted because this is the principle. And the principle is that the buyer should get a clean slate. Prior period liabilities to be discharged and settled in accordance with section 53 of the code. Yes, very much. Bidder CD will have no liability arising out of non-compliance prior to the effective date. This relief has not been granted by adjudicating authority. Continuation of the liquidation account for settlement of future claims and maintaining it till closure of process. This relief has been granted. Continuation of license, approvals, contracts, and leases granted in favor of the CD without disruption due to commencement of insolvency proceeding. This relief has also been granted. Pecuniary liability obligation, if any of the non-compliance, including tax liability of the CD till effective date, as should be handled as per section 53. Yes, this relief has been granted, and very rightly so. CD to have right to review and terminate existing contracts in order to ensure business viability. This relief has not been granted. Of course, and why should it be? It will all depend upon the nature of the contract. The claims of the CD against third parties and related parties shall remain recoverable, and CD shall have the right to proceed against such parties. No, this relief has also not been considered by the adjudicating authority. Immunity to CD from inquiries, investigations, or any other proceeding on account of matters prior to effective date. Yes, Ghanshyam Mishra principle, yes, it has been provided. No disability of CD or successful bidder in terms of 29A, not granted. Extinguishment of promoter shareholding in non-public without consideration, including approval of proposed structure. Yes, it has been granted, quite rightly so. Allowing liquidator to issue equity shares of the CD to bidder or its nominees as specified in the structure out of sales amount. Yes, it has been provided. Permitting infusion of balance sale consideration by bidder or its nominees by way of issuance of securities allowed. Change in status of the CD from liquidation to active in MCA records allowed. Encumbrances charged in ROC should be treated as satisfied allowed. Empowering liquidator to reconstitute new board nominated by bidder allowed. GCS to be treated as similar to resolution plan, and all benefits, privileges, exemptions available in any law shall be made available allowed. Tax benefits and exemptions to continue to be applicable to CD from effective date, including benefits under 79(2)(c) of the Income Tax Act. No, this cannot be allowed, and it has rightly not been allowed. Exemption from stamp duty surcharge upon acquisition of plant, not allowed. Enabling the liquidator for facilitating sale by making requisite accounting entries for smooth transition was, I don't know why it was not allowed, but yes, this particular thing has not been allowed. Because the A thought that yes, it is a normal operation, and there cannot be any impediment in such case. So exemption provided under SEBI ICDR regulation and SCRR regulations, whatever was applicable under section 31, that was mutatis mutandis, it has been allowed. Benefits accruing out of avoidable transaction shall be deposited in liquidation account, and related costs to be borne out of the liquidation account and borne by the liquidator beneficiary was not considered by the adjudicating authority. But I think this should have been pressed more for consideration, because all benefits arising out of avoidable transactions should go to the beneficiary, and the costs related to it should not be on the liquidator or the resolution professional till the case is disposed. CD to approach adjudicating authority if any difficulty in implementation of going concern sale of CD has also been allowed. Now, very interestingly, Honorable NCLAT, New Delhi, via its order dated 11th January 2022, in the matter of SV Ramani Liquidator versus Visist Services Limited, concluded that going concern sale means sale of both assets and liabilities if it is to be stated on as is where is basis. Now, this created a lot of hue and cry when this order was passed, because the entire concept and understanding of going concern sale was under a challenge. Because as we professionals all knew that liabilities have to be considered in accordance with Section 53 and gets extinguished. But this order says that no, I'm not permitting any going concern sale because it is only containing sale of assets as a part of going concern bouquet, and it is not containing any liabilities. And the liquidation regulation also prescribed that it should be a bouquet of assets and liabilities, and therefore I am not allowing the GCS. But I think there must have been representation and news articles, etc. And the very same bench in 8650 of 2022, by its order dated, not after, just after 28, 29 days, on 9 February 2022, in the matter of KTC Food Private Limited, held otherwise, it stated that it is settled law that when sale proceeds of CD is distributed in order of priority and in the manner prescribed in Section 53, claims of any other creditor cannot be entertained contrary to the provisions entailed in under Section 53. Subsequent to the distribution of sale proceeds under 53, no other entity, including government entity, can claim any past, unpaid, or outstanding dues against the appellant who has purchased the CD as a going concern. The objective of the code is to extinguish all claims, specifically the ones which were not even made during the CIRP or in liquidation stage, to aid the purchaser of the CD as a going concern to start on a clean state. The purchaser of the CD, even in liquidation stage, cannot be burdened with past liabilities when it is not mentioned in the sale notice. CD not to be burdened by any past or remaining unpaid outstanding liabilities prior to the sale of CD as a going concern and after payment of sale proceeds distributed in accordance with 53 of the code. There are other issues, multiple mode of sale in single e-auction. Yes, I think we have seen various examples. So as a liquidator, apart from going concern sale, you can also come out with the other mode of sale simultaneously by a single e-auction notice very clearly stating that the first priority will be going concern sale. So this way you can save time and of course you can fast track the entire process. Of course, the UI process, as I told you, the going concern sale process needs to be embedded as part of the regulations, because liquidators are really facing a lot of problems because there's no clarity in the code, and there are often questions asked, costs incurred, time lag is there, the approval of the process also takes time. So all these things, if it is streamlined by way of regulation, I think it would fast track the process and it would be comfortable for the liquidators who are dealing with the entire process. There's also a question being asked that who shall apply before adjudicating authority for reliefs and concession, because often a buyer comes and puts in a condition that, okay, I am willing to acquire this company as a going concern, but then I don't want any past liabilities. The code is silent on it. There may be judicial pronouncement, but then these judicial pronouncements are specific to the cases where the matters have, where the applications have been filed. So we would also want the liquidator to file an application seeking reliefs and concession. The liquidators are always confused that why they should apply for reliefs and concessions on behalf of the resolution applicant. It is only their duty to put forward the acquisition plan containing the reliefs and concession before the adjudicating authority, and also make resolution applicant or the acquirer a party so that it can pursue its own case while this application for approval is filed by the liquidator. The liquidator is an independent person and he should not be seen taking sides of any intended buyer or an acquirer. So his duty, in my opinion, is just to present the entire facts before the adjudicating authority by making the successful buyer or an intending buyer a party, and let the entire intending buyer, who is a party in this case, fight his own case, and the adjudicating authority thereafter may consider and pass a judgment. But yes, now it is very clear that what reliefs and concession can adjudicating authority provide and what it cannot. So whoever is intending to acquire as liquidator, we can make them aware based on various orders and precedences which are now in front of us. 18 such cases are there in front of us. And of course, the handover to successful bidder is also a very tedious task. The liquidator, before handing over, should ensure that nothing comes back to him, and therefore nothing is provided in the code. But yes, he should very ably record everything which is being handed over, everything which is being transferred. Often liquidators are come to us for advice that yes, whoever is the successful buyer, they are saying that okay, you complete the accounts, you sign the balance sheet and give it to us. And there is also an accounting challenge, because when the liquidation process starts, the liquidator is only required to prepare a receipts and payments account, and they do not prepare the accounts of the company under the Companies Act 2013. And if the liquidation process takes more than 1.5, 2 years, 2.5 years, and then thereafter there is a going concern sale, and there are various such examples, the liquidator would not have prepared the accounts for 2 years. He would have just prepared the receipts and payments. So in that case, what happens? Who takes the responsibility? How will the income tax department react? How will the Ministry of Corporate Affairs react when the intending buyer steps into the shoes of the corporate debtor and tries to regularize everything? So the intending buyer often tries to put everything on the onus of the liquidator, and quite rightly so, because he was in command prior to him being on board. And liquidator is also left grappling with the situation, because the law only provided him to prepare receipts and payments and not the full accounts. So these are some challenges. I happen to be before the Insolvency and Bankruptcy Board of India, and I've also submitted my note highlighting all these issues. I hope that the board will look into it, and probably these issues will get settled. So of course, in my opinion, it is really challenging for the liquidators and resolution professionals of the initial years, because to handle all these things, because law is still evolving and law is still getting settled. So there would be questions, there would be decisions which may go wrong and which may fall back upon the liquidator, but or the resolution professional. But yes, this is how any law evolves, and this is how any law would function. So we should continue doing our best, and I'm sure this is what I had to present. I'll be happy to take questions. Thank you.
Yeah, Mr. Navneet.
जी सर.
हाँ, चैट बॉक्स से 2-4 क्वेश्चन हैं, सबसे पूछ लीजिए. और
ठीक है सर. Sir, there is one query from Swinder Singh sir, that if company is closed for more than 1 year, whether it can be sold as a going concern?
Yes, I showed you a case law. No, it just mentioned whether with running or not running, it can be sold as going concern.
Next question is, because our Swinder sir always ask very relevant questions. One more question is there. In case of sale as a going concern, losses, if any, is to be carried forward and for income tax and other purposes or not?
So Income Tax Regulation, Income Tax Act does not provide any exemption, just like the corporate insolvency resolution process, wherein when the company change hands, the carry forward losses can be adjusted with the profit, even if there's a new buyer. So there's a specific exemption provided in the Income Tax Act for the CIRP purpose, but not for the liquidation purpose, and hence it is a setback today. Of course, things have to be represented before the relevant authority. I have already placed this before the Insolvency and Bankruptcy Board of India.
Thank you, sir. From IIPA side, we will also make a representation in this regard. Manoj ji, we should take note of this thing, because very relevant question was asked, and this is in fact a need of the hour also. Next one was, is it compulsory to offer GCS under liquidation or not?
So it is not compulsory. That today the law is very, very clear that when the company is about to go into liquidation, which means if the CIRP has failed, at that point of time, the COC will recommend to the resolution professional, who would be the incumbent liquidator, that he should go for a going concern sale or sale of business as a going concern. And if they do not recommend, and if the liquidator also feels that there's no case for going concern
Going
sale
concern.
as far as a particular entity is concerned, then it is
Okay.
not mandatory for him. Of course, he has to have his reasons, because see, if there are only real estate assets, if there's no business in the company, there cannot be any going concern sale, right?
Right.
And one important thing before I take the next question, which I missed out.
Yes.
I just wanted to say that in case of valuation, whenever we are engaging into CIRP, normally we arrive at the fair value and the liquidation value. But going concern sale value is not arrived at. So whenever there is such recommendation, the valuation exercise of going concern sale has to be taken forward when the liquidator when the resolution professional steps into the shoes of the liquidator. Most of the professionals tend to take up the fair value as going concern sale, but in my opinion, no, that is not the right approach. The registered valuers, they follow the valuation standards, and as per the standards, they have certain assumptions while we are arriving at the going concern figure. So this is an important thing which a professional should keep in mind for arriving at the right reserve price.
But sir, one thing is there, it may happen because any of the regulations specifically do not provide for any type of valuation as a going concern, because that talks about only fair value and liquidation value only.
So
Won't it
I'm not
backfire?
I'm not a registered valuer, but so do you want to say that the fair value is akin to going concern value?
No. We are not saying that.
Okay.
Yeah, Manoj, please.
या इसमें हमारे वैल्यूएशन स्टैंडर्ड्स हैं जो हमारे को डिटरमाइन करवाते हैं कि एज ए गोइंग कंसर्न हम वैल्यूएशन कैसे करेंगे. तो दैट स्टैंडर्ड्स आर देयर, बट आई फुली एंडोर्स सुनील जी व्यू कि ये प्रैक्टिस नहीं है, और ना ही इनफैक्ट वी पीपल आर अवेयर ऑफ इट कि वी शुड हैव द गोइंग कंसर्न वैल्यूएशन डन आल्सो. इसके अंदर मैं थोड़ा सा और बताऊंगा कि जैसे स्लम सेल की वैल्यूएशन आती है, उसकी भी वैल्यूएशन स्टैंडर्ड्स है. क्या स्लम सेल को कैसे करोगे टैक्सेशन के अंदर? वी हैव गॉट इट डन. We have got it done in case of other than IBC cases. So है सर.
एक चीज और है कि जीएसटी की भी लायबिलिटी स्लम सेल में नहीं आती है, गोइंग कंसर्न में नहीं आती है, बट इन केस ऑफ पीसमिल जीएसटी की लायबिलिटी आती है. सो फॉर ऑल द लिक्विडेटर्स हु आर handling liquidation assignment, and if there is a slum sale or a going concern sale, normally the GST liability does not arise, but in case of piecemeal sale it arises. So let us be very careful, because if we make a mistake, then the GST liability will come on us. So we have to be very careful and take a informed opinion and informed decision before proceeding into the process.
सर मैं आपसे एक क्वेश्चन दोबारा पूछना चाहूँगा. You mean to say that in case of this going concern sale, GST is not applicable? Sir, what
no, when assets are sold as a slum sale, right? And when I say slum sale, it means that you are selling a running unit without assigning individual asset value to a specific asset. Then in such case, there is an exemption from GST. GST is not applicable.
No, but if you are selling as a going concern, is GST exemption still there?
No. Going concern sale mein
GST yes.
No.
Actually, this is what I want to say. But in case of selling of going concern, GST is applicable. Yeah.
Sir, one more question is there. That what is your opinion on vicious judgment? Should liabilities also be included apart from assets?
Who am I? Now the NCLAT has said, I mean, I bow down before the revision judgment of the same bench, and that should be the way forward.
Right.
Yeah. आपने बड़ा डिटेल में बताया इस point.
Yes. So one last, Manoj ji, one last question is there. You want to add on to it? Please add on. Manoj ji.
नहीं सर, बीच में कोई आए थे तो जरा उनसे पूछ लो. One of the audience was there. Mr. Prasad was there. Mr. Prasad, you want to ask something?
Yeah, I have few questions, sir.
Yes,
Number
sir.
one, see, under the income tax, actually it defines the slump sale as a going concern sale.
Correct.
Under IBBI, slump sale is different, going concern sale is different.
Yes.
So if I take that objection, then whether income tax should rise, no, I mean, you should raise that no, it is not so like that. Or even the same thing is the commercial tax is also same thing. Slump sale is as per their definition, slump sale is also going concern sale. Whereas as per IBBS, slump sale is different, going concern sale is different. So
IBBI will prevail. IBBI will prevail. The IBC will prevail.
Yeah. So for the going concern sale also, I mean, slump sale under the IBBA sale, does it attract GST or not, sir?
No, it does not.
It does not attract.
No.
Okay. And one more thing, sir. See, at the end of the CIRP, the COC felt that, it is going concern sale is not to be opted because of condition of the CD. But subsequently, because some stay orders from High Court, all those things matter prolonged more than 1.5 years. Now, liquidator, can he think of, I went to the NCLT also. NCLT said follow IBBA regulation. So I decided to go for the business of the sale of the business of the seed as a going concern. I opted it. Of course, that also again stalled by the High Court stay. Number one, because at the starting of the liquidation, I have not appointed the valuers, registered valuers, for the valuing the business of these as the CD. I have taken the values, individual values of the financial assets, plant and machinery assets, and the land and building only. So is it right or wrong, or should I go now? Because the time is already over.
No,
for
sir.
appointing the valuers.
See, the objective of the code is revival, and objective of the code is value maximization.
Yes.
And even if the COC felt otherwise, if the liquidator feels that yes, sale of business as a going concern is a better proposition and is a viable proposition, then you can still go ahead with it. But yes, please record your reasons in writing. Nobody will ask you any question, number one. And number two, before doing that, please go for a valuation, because what reserve price will you fix for businesses which you are intending to sell as a going concern? So this has not been arrived at. So you should go for a valuation based on which you will arrive at the right reserve price for that mode of sale.
But liquidation regulations call for only the appointing of the registered values only within the first 1 week, or not after that.
Right. So in that case, you may also consider approaching the National Company Law Tribunal. See, is your COC agreeing with your view? Is your SCC stakeholders?
Yes, sir. Stakeholders have approved it.
They have approved it?
Sale of business as a going concern has been approved by the stakeholders. Even the reserve price also has been fixed by them only. Reserve price also fixed by them.
Reserve price has been fixed by them.
Yeah, because it was latest regulations. I think last year October, say that it has to be discussed, and like that regulations have been made. In line with those regulations, I opted for that way. I informed them.
No, but what I remember is that, and please correct me, that the reserve price can only be based on the valuation, average of the valuation.
Yes, sir. On the valuation only. The reserve price is slightly higher than the valuation only.
Okay. So then it's okay.
Combined valuation of all the assets put together, the reserve price is higher.
Okay, fine. Then it's okay. Then if we are going at a higher price, then there should not be any issue.
Agrees. And one more thing is, suppose it's the sale of business as a going concern is getting stalled repeatedly by intervention of the various authorities like High Court, all those things. So can I go on repeating it for the next? Already liquidation started 2.5 years back. Of course, more than 1.5 years is under High Court stay only. Can I go on repeatedly say that?
No, but when it is stayed, how can you proceed?
Yeah, it stayed, but now so after 3 months, 4 months, again the High Court stay gets vacated. At that time, again, can I go for the advertisement of the sale of the business?
Yes. When it is vacated, then you have to go. Sir.
Yes, because its time frame is 2 years, 3 years, like that is going on. That's why I got a doubt.
No, in that time frame, the stay period will not be included, sir.
Okay.
Yeah, that is there.
Okay, sir. Right,
Condition 46, I remember.
Yes, sir.
Sir, here one more question is there. That since he has agreed for selling it at a already fixed price, have you got buyer for that? price you feel?
I have the buyer. I got the two people have submitted their EMD. So one day prior to the actual auction sale, I received a stay order from the High Court.
No.
Tomorrow,
Sudhiji, my question is, can we proceed with those buyers instead of going for new process of auction and all this thing? Reason for that is that when stay is granted there, the moment that stay is over, he can go with the earlier,
Yes. Yes.
the price also.
Yes.
This is what I want to hear.
Yes,
There's no
yes.
need for you to go for further auction and all this thing, because when you have already got the buyer, you can go with them also.
Right.
Yeah,
Sir.
but EMD has been returned, and based on that, the individual bidders, they approached the High Court. High Court has allowed the refund of the EMD, so I refunded the EMD. So now I have no other option again going further. It's almost more than 8 months. It is still under stay. So they approached the High Court. High Court has given okay, the EMD can be refunded.
Okay. So then you have to come out with auction.
Because auction itself is a very big headache. It will take you another minimum 15 days to 1 month for running the whole process.
Correct.
Which is again a very big headache.
Correct.
And at the same time, you will lose your fees also because of increase in days of your result. That is also a very big hurdle. Sir, sir, I would like कि हमारे चीफ गेस्ट सर इसके अंदर कुछ ऐड करें. निपुण सिंघवी जी, आप हो? Are you connected with us?
सिंघवी जी नहीं है. खुराना सर से
रिक्वेस्ट है. You please add or to it.
सर इतना अच्छा उन्होंने जो है वो पूरा सेशन लिया है कि कोई क्वेश्चन ही नहीं छूटा है इसके अंदर कि कोई क्वेश्चन रेज करने लायक रहेगा. बस मैं तो यही कहूंगा कि सर कि जब भी गोइंग कंसर्न में हमने सेल करना है तो उससे पहले एक बार अपने को जो है वो फूफे की भी जो है वो एक बार ट्रांजेक्शंस को जो है वो चेक कर लेना चाहिए कि कोई ऐसी कोई ट्रांजेक्शन तो नहीं आई है कि जो कि हमारी लाइमलाइट में हो, कि जिसको भी अपने कॉग्निजेंस देना हो, सो दैट एट द टाइम ऑफ डिसबर्समेंट ऑफ द प्रोसीड्स वो हम उसको देख सकें. रिलेटेड पार्टी में 2 साल है और अदर देन रिलेटेड पार्टी तो 1 साल की ट्रांजेक्शन है. और अगर मान लीजिए उसके अंदर कोई फ्रॉड एंगल अगर कोई ऑब्जर्व होता है तो उसके अंदर कोई टाइम लिमिट नहीं है, तो भी एक बार एंगल को उसको देख लेना चाहिए ताकि आगे आने वाले टाइम पे फिर जो है वो कोई भी लॉ एनफोर्सिंग एजेंसीज जो है दे शुड नॉट पुट एनी क्वेश्चन मार्क कि दैट इज यू हैव नॉट सीन ऑल दीज थिंग्स. तो नहीं तो फिर वो आरपी के ऊपर जो है वो फिर काफी स्ट्रक्चर्स डाल देती है, फिर वो IBVI को भी लिख देती है इफ दे कम अक्रॉस एनी सच इंफॉर्मेशन. तो मेरा ये था कि दिस एस्पेक्ट हैज टू बी लुक्ड इनटू बाय ऑल आरपीस.
थैंक यू सर. मनोज जी, निपुण सर ज्वाइन कर गए हैं. निपुण
सिंघवी जी ज्वाइन कर लिया आपने? हेलो, हमारे वकील साहब, ये he is also very literate and has a very good experience. सर मैं देख नहीं पा रहा निपुण सिंघवी जी को. आप देख पा रहे हो?
हाँ, निपुण जी ज्वाइंड है अभी, बट ही इज ऑन म्यूट प्रेजेंटली. चलिए सर, कंटिन्यू.
चलिए, टाइम इज अप. सर एक तो क्वेश्चन आई वुड लाइक टू शेयर विद ऑडियंस. जब हम गोइंग के साथ हम किसी को बेचते हैं तो 29E की जो एप्लीकेबिलिटी है टू द बायर, is that to be considered or not? Sir, in my opinion, that has. बताइए आपका क्या opinion है इस पे? Then I deliberate on it.
हाँ, तो हो गया ना, सुप्रीम कोर्ट में डिसीजन आ गया ना अरुण कुमार जगतराम का केस में. हाँ जी. 29E has to be considered whether in going concern and yes. Even in section 230.
Yeah, even section 230. बिल्कुल ठीक बात है. अच्छा, एक थोड़ा सा प्रैक्टिकल एस्पेक्ट बताइए. जैसे हम लोग एज एन आरपी वी आर डूइंग दिस वर्क, तो रेजिडेंट एप्लीकेंट को हम नेचुरली गोइंग कंसर्न लिक्विडेशन में वही बिकेगा जो हम नॉर्मल कोर्स में क्रिप्ट के अंदर वी कुड नॉट फाइंड एनी आर, तो वही नेचुरली लिक्विडेशन में आएगा और बिकेगा. Can you little bit enlighten us how even if we want to plan this aspect, that we instead of finding an RA, we go for selling going for selling as a going concern in liquidation. तो दोनों के बीच में सेकंड कोर्स के अंदर जब हम एज ए गोइंग concern liquidation में बेचते हैं, क्या बेनिफिट एडिशनल हैं? you already told कि इसमें ये additional benefit था, लेकिन comparatively flip में आरए को देना और इसके अंदर एज ए गोइंग कंसर्न बेचना, इसके अंदर क्या बेनिफिट जो लॉसेस हैं, ये थोड़ा सा एक प्लीज एस्पेक्ट बता दीजिए फ्रॉम प्लानिंग एंगल।
देखिए, apart from the other benefits which I just mentioned, the largest benefit is that instead of selling the assets on a individual basis, the entire process happens at one go. So that saves time. It also saves on your cost. And of course, the biggest satisfaction is that the company revives. So above all tangible benefits of any magnitude, by savings in liquidation costs, saving in time, the biggest benefit, which is the objective of the code, that is revival, and that is being met. So that is the only benefit, biggest, largest benefit which I can see.
Yeah, that is it.
Manoj, I think we can conclude now.
Yes, yes. Vote of thanks के लिए मैडम है तो उनको बोल दो।
मैडम नहीं है अभी, so चलिए सर, I convey my thanks to sir. Sir, it was really a wonderful presentation. We have got the comments from the audience. They have liked it very much. And Rajiv sir, thanks a lot for sparing your valuable time. Prasad sir, thanks a lot for raising the questions and making it more lively. Thanks a lot to all. Please keep joining us in the programs in future. Thank you. Thanks a lot.
Thank you. Thank you very much.
Thank you very much. Sumit ji, thank you very much.
Thank you.
Sir,
Thank you,
I would
Rajiv
also
ji.
like to give the thanks to Manoj ji, Navneet ji, और सारी जितने भी ऑडियंस हैं सबको थैंक्स देना चाहता हूँ। That is, they have given a wonderful presentation. Thank you very much.
Thank you.
बिल्कुल ऑडियंस है तो हम हैं, अगर ऑडियंस ना हो तो हम भी नहीं होंगे। तो सुमित जी, हम आपको आगे भी तंग करते रहेंगे, ऑलरेडी थिंकिंग ऑफ वॉलंटरी लिक्विडेशन, उसको भी देखते हैं आगे क्या करना है। लेट्स सी विद द पैसेज ऑफ टाइम, हम आगे भी आपको हक से तंग करेंगे, एंड आई होप यू विल एंटरटेन अस एंड
Definitely. Thank you.
and
Thank you.
thank you, Ji. Thank you, Sumit ji. I'm closing the meeting now. Thank you very much.
Thank you.